Great. Well, I'll just mention again to thank you all for joining us and thank the folks who hope are listening later. We hope to post this both at the Dauphin County Bar Association website and the Dauphin County Library System website. So folks who are not able to attend, be with us live, hopefully will be watching this in the future. And we are delighted to be part of this partnership with MidPenn Legal Services, Dauphin County Bar Association, and the Dauphin County Library System to just help the community better understand some of the legal issues. We chose these topics based on what the librarians had encountered in terms of questions. So we are delighted tonight to have Lyndsay Conforto join us to talk more about custody law, and we look forward to your questions. Again, feel free to unmute yourself, speak up. We're a small group here tonight. If you have questions or need to have something explained, again, a lot of times I get confused when people use abbreviations, for example, so don't hesitate when you don't understand it in the jargon. And we will have time for questions, and we hope we'll be done in less than an hour, but we look forward to Lyndsay's wonderful, and isn't it a delightful PowerPoint? I think this is my favorite PowerPoint, hands down. And that with that, I'll turn it over to Lyndsay Conforto. Thank you.
So my name is Lyndsay Conforto. I'm a custody attorney with MidPenn Legal Services in Dauphin County. Just a little bit about our organization is we have 15 different offices. We cover 18 different counties, and we do, in addition to custody, things like landlord-tenant, public benefits, some protection from abuse in certain counties, unemployment compensation, and some other civil legal aid things. So, but today we're going to talk about family law, specifically custody, which is primarily what I do. And there we go.
Wow.
This is just like a fun little video I thought we would kind of start with, just to kind of illustrate something.
Spider-Man. Hey, Daddy, you the man? Are you the man? Are you the man? You know what's real?
Okay, so we start with that kind of funny video because custody is we say better parent in quotes. I mean, realistically, both parents are absolutely fine, able to care for children in most situations. It's just, there's always situations where things seem like they're fine when people are part of a family unit and they're together, such as these kind of jokey Halloween pranks. But as soon as people split up, those things become kind of not okay, and people try to use them against the other parent in a custody context. So it's just kind of one of those things where, you know, it's cute and fun when you're together, but, you know, someone may go to court and say, oh, well, dad tried to scare my daughter, or something like that. So it's just kind of an example, a more humorous example of some of the things that we see with custody to kind of get started today. So when thinking about custody, there's always some preliminary considerations. And the first one is, even should you file for custody? A lot of times, you know, you don't need a court order to tell you what to do. I mean, if you and the other parent are able to work things out on your own and get along relatively well, then there's not really a need for a court order. So that's just always something that you should consider. If you know if a child lives primarily with one parent and the other parent you know, really doesn't see the child, doesn't ask to see the child, isn't in the picture at all, you know, again, there's not necessarily a need for a court order because you as the parent who has the child are able already to do most and everything and make all of the decisions regarding your child. There are pros and cons for filing for custody. So those are all things that you want to consider. Obviously, some of the pros for filing for custody, or you will get a court order that you will have to follow. That I like to say it protects both parties, right? It protects your interest and your time with the child. It also protects the other parent's interests and their time with the child. And that would lead to, if one parent, with a court order, they wouldn't really be able to withhold the child. There would be contempt consequences for that situation. When considering these preliminary should you file, some of the cons for filing a custody action are that if the other parent really isn't that involved, it may prompt them to get more involved. They're going to get custody paperwork that you filed. They're going to be invited to come to court, invited to come into the process. And they may say, yeah, you know what, I do want to see this child more often. And, a court is usually always going to give a parent the opportunity to be involved in their child's life. So the other party may actually end up getting more and asking for more custody than you may have hoped by filing in the first place. So those are some all just kind of preliminary issues generally to kind of think about. Every situation is different. So, you always have to kind of think about, your situation and the facts of your case. So these are the kind of how it works in every county. Does custody a little bit differently, but this is the steps for filing a custody action in Dauphin County. So the step one, you would file a custody complaint, which that initiates your custody action. Or if you already have a court order you're trying to change or enforce, you would file a modification or a contempt. If there's some sort of emergency situation, you could file what's called a petition for special relief. After that paperwork has been filed at the courthouse, the court schedules every party to attend a seminar. Right now, the seminar is being held virtually, but previously it was in person at the courthouse. And then after that, you are scheduled to attend a custody conference. And this is a more sort of informal type of mediation where the parents can sit down and try to work out an agreement. If an agreement is not able to be reached at the custody conference, then your next step would be to attend a pretrial conference with a judge. And that is an opportunity for the judge to hear what the issues are in the case, to meet the parties, to hear how many witnesses are likely to be needed, and to help hopefully narrow the issues and reach an agreement. If an agreement is not able to be reached at that stage, then you will be scheduled for a full trial in front of a judge. So for the step one, filing a complaint or a petition for modification, we just have listed here a lot of the things that you're going to need to file. So these are things that you should have ready and know them before you kind of get the paperwork. So you're definitely going to need to know who the parties are and what their addresses are. And that is really important to know the addresses. You will need to be able to prove to the court that the other party has received a copy of the paperwork in case they don't show up to court. So that's, sometimes if we don't have an address, unfortunately, it is really hard. There are ways to still file paperwork and you have to go through a special process to be able to serve if you don't have an address. But realistically, the problem comes in where you may get an order that gives you, custody of the child or something. But if you can't find the other person, you can't really enforce the order. So it's, we just think it's important to have that address. You're going to need the name, the date of birth, and the address of the child or the children that you're filing for. When you are doing an initial complaint, you will need a list of where the child has lived for the past 5 years. And then you'll have a brief reason for why you're filing the complaint. It could be as simple as, I just want an order so we all know what's going on, or it could be a little bit more detailed with what your specific situation is. In Dauphin County, you will also need to file a criminal affidavit, which has it's a whole long form with a bunch of check boxes that you check yes or no if you have a certain criminal conviction, or have pled guilty or no contest or have pending any of the charges that are listed on that form. There's you would need a prior court involvement form, which is just lets the court know if there's been any other cases in Dauphin County. In Dauphin County specifically, they try to keep the same family with the same judge for different types of cases. So there's consistency in cases. You would also want to file an informa pauperis, which basically is asking the court to waive your filing fees if you qualify for that. And you would want to also file a confidential information form, which is it's been a couple years now, but a slightly more recent change where on the actual complaint, you cannot list children's full names and birth dates, and you put it on this special form just so that if it gets online, the court knows not to put this form online. And then there's a certificate of service attached, which just basically lets the court know that you did send it to the other parent. And then this is, we're going to start talking about the custody conference. And this is just another quick kind of cute video about how not to act at a custody conference. Okay, so that was just another kind of cute video about definitely how not to act at the custody conference with the other parent, even though you may want to, but usually in court that type of yelling is frowned upon. So the next stage would be the custody conference. So all parties would be present for that with their attorneys if you have any. And the purpose of the conference is to reach an agreement. So the parties are able to present their position of the case. It usually always starts with the person who's filed the paperwork. They get to talk first and say, this is why I filed, this is what I'm looking for. These are my concerns with the other parent. And then the other parent gets a chance to respond and say, this is, my position on that. This is what I'm looking for. This is how I see the case. This is not it's less formal than a trial. It's not an evidentiary hearing. So you don't need to have witnesses. You don't need to have evidence. It's not recorded. There's no court reporter. It's just, you sit down with an attorney who acts as your mediator to hopefully help you and the other parent resolve the custody case. So only parties and their legal counsel may attend the custody conference. Conference officers may be able to recommend an order of court, depending on the county. In Dauphin County, they do that sometimes. It depends on the situation if there's no agreement. And in certain situations, they may also recommend a risk assessment, a mental health evaluation, or a drug and alcohol evaluation if the case warrants those types of evaluations. So for a custody case, there's two sides for custody. So the first is legal custody, which is the right to make decisions on behalf of the child or the children, which includes medical, religious, and educational decisions. Typically, in most cases, these are shared by the parties or the parents, which requires them to work together to reach decisions that are in their children's best interest. Which just means that, one parent can't unilaterally change their doctor without talking to the other parent. Obviously, parents can make emergency decisions on their own and then tell the other parent as soon as possible. But that shared legal custody means that, both parents have to work together. It is possible for a parent to have sole legal custody, which is just when one party is given the right to make those decisions, but it is more rare. The court really does prefer that parties share that and work together for the benefit of their children. And then there's a bunch of different types of physical custody outcomes that could happen at the conference. So this is the physical custody is the actual custodial schedule. So where the child physically is at any given time. And it can range from sole physical custody, where one individual has exclusive physical custody and the other party doesn't see the child at all. That's extremely rare and is limited in certain situations, typically if one party is incarcerated or something like that. Primary physical custody is where one individual has the child the majority of the time. Shared physical custody is where both parties or parents, they have equal or significant time with the child. Partial physical custody is basically any period of custody that's less than primary physical custody. So if it's, you have a parent who has alternating weekends and maybe a couple weekdays, that parent would have partial physical custody because they have less than the majority of the time. Or supervised physical custody. So a parent can have custody that is monitored by an agency or another adult. If your case does not settle at the custody conference and you don't reach an agreement, then your next step is the pretrial conference, which all parties must file a pretrial statement with the court at this stage. It lets the court know what you're looking for, what exhibits you might bring to trial, and who you would intend to testify on your behalf. So all parties and legal counsel, if any, must be present. And then they usually meet with the judge to try to narrow the issues and another attempt to reach the agreement. A judge at this point may also issue an interim order establishing, a custodial schedule until the full trial, or they may not. So at the trial stage, all parties and witnesses must be present. The judge decides the issues of custody presented by the parties. And here's where we get into kind of the nuts and bolts of how the court makes their decisions for custody. So a trial court will make a decision. They have to consider 16 factors, and this is by statute. These factors have been laid down by our Congress here in Pennsylvania about what they think is important for a court to consider when making a custody determination. So quickly kind of go through these factors. So the first is which party is more likely to encourage and permit frequent and continuing contact between the child and another party. So this is a big one. It's one that usually trips a lot of parents up. You don't get along with the other parent for whatever reason, and that's probably the last person you want to reach out to and try to include in your child's life. But it is the first factor, is the willingness of the parents to sort of look out for each other and share custody of the child as practical and safe in your situation. So that is something that the court does look to. The next one is the present and past abuse committed by a party or a member of the party's household, and whether there's a continued risk of harm to the child. The third factor is the parental duties performed by each party on behalf of the child. So these could be, obviously, do you take your child to school? Do you take your child to the doctor? Do you cook for your child? Do you give your child a bath? All those types of things fall under what parental duties you would perform. And typically, both parents are perfectly able to perform parental duties for the children. Number 4 is the need for stability and continuity in the child's education, family life, and community life. Stability is a big factor. The judges try as much as possible to not necessarily have children bouncing around from home to home, from different schools to different schools. They kind of, want children to be able to have that structure. 5 is the availability of extended family. The 6th factor is the child's sibling relationships. Number 7 is the well-reasoned preference of the child based on the child's maturity and judgment. Typically, it's teenage years is when the court really starts, probably speaking to children and taking their well-reasoned preference into account. So probably, maybe 13, 14 and older. Number 8 is the attempts of a parent to turn the child against the other parent, except in cases of domestic violence where reasonable safety measures are necessary to protect the child from harm. So again, this is one that sometimes, it's hard, but, you want to try to show that you do try to include the other parent sometimes, and you are willing to allow that other parent to have time with the child. Number 9 is which party is more likely to maintain a loving, stable, consistent, and nurturing relationship with the child, adequate for the child's emotional needs. Number 10, which party is more likely to attend to the daily physical, emotional, developmental, educational, and special needs of the child. And again, this is pretty similar to one of the factors that's before. A lot of them do overlap. Number 11 is the proximity of the residences of the parties. Obviously, the closer that the parties live to each other, the easier it is to do more of an equally shared custody arrangement, especially if the child is school age. If farther apart, the court then kind of is forced to make a decision about maybe one parent needs to have the child more often during school. Number 12 is each party's availability to care for the child or ability to make appropriate child care arrangements. 13 is the level of conflict between the parties and the willingness and ability of the parties to cooperate with one another. 14 is the history of drug or alcohol abuse of a party or a member of a party's household. And this is where we had talked before that sometimes the court can require and order drug and alcohol evaluations if they feel that, they need to know more information about a party's drug or alcohol abuse history. Number 15 is the mental and physical condition of a party or member of a party's household. And again, the court can order a mental health evaluation if that is something that, they're concerned about and feel that they need more information about a party's mental health. And then 16 is any other relevant factor. So basically it can be anything. We usually school district is something that the courts will consider, whether one parent smokes or no in the house or doesn't. Vacations, any other type of thing that the court can consider they may hear. So for trial, these are just some things that I usually like sharing with the court. So I thought it would be helpful exhibits for the court if you're presenting your case. Photos of your clean residence, particularly the child or the children's bedrooms. I think the court likes to see that, you have adequate space and housing for the child. I always like showing a few recent photos of the parents and the child and things you like to do together, whether you go to a baseball game or it's a t-ball game or you go ice skating or something like that, or some photos with siblings and extended family if that's available. I think that sometimes the judges hear so many negative things at a custody trial that it's nice to see some positive things and some positive photos about the fun things that parents like to do and the child having a good time. Any relevant text messages with the other party, either show lack of co-parenting or that could relate to any of the other factors that we just discussed. I always like to say, be careful with your communications and your social media posting if you're involved in a custody battle, so to speak. Never text anything you wouldn't want the judge to read, because that may come back to hurt you if you do. Or school attendance records or something like that if, for example, the other party isn't taking the child to school and you want to be able to show that to the court. So here's just these are some tips for just going to court for custody. Obviously dress appropriately for your custody conference and trial. And this also, if it's virtual or not virtual, it's the same. You want to still be able to show the court that, you're dressed appropriately, you're taking the proceedings seriously. Do not interrupt the other party when they're speaking. That's a big no, especially At the custody conferences, you will have the opportunity to respond. So just let the other party say what they're going to say, and then you can always respond with, well, that's not true. This is what actually happened. So you will get that opportunity. If right now our custody conferences are still being done virtually. Some of our custody trials and pre-trials are also being done virtually, although some of the hearings are starting to be a little bit more in person, as COVID restrictions are lifting and people are getting vaccinated. But if your conference is virtual, just have a clean, uncluttered background, good Wi-Fi signal. Try to be in a room where you can participate with no distractions, no dogs running in and out, no kids running in and out and things like that. So you can be, focused on what's going on with court. Be respectful, and then also speak clearly and slowly so everyone can understand what you're saying. And if you're at a trial, so the court reporter can type down what you're saying. Now, here, I don't know if we necessarily need to go through every single one of these, but there is a process for relocation. It's part of every court order that parties are not permitted to relocate the child unless they have consent from the other parent or an order of court that allows them to do so. So relocation is, typically defined as moving where it would impact the other person's periods of custody, although sometimes even switching school districts, the court gets a little bit upset about that. So it really depends on the individual circumstances. So in addition to the 16 factors that we discussed before, the court takes a look at these 10 factors, which is mostly whether the move, focuses on whether the move would benefit the child in some way and kind of what contacts the child would still have with the family member or the parent who's not moving. So that's, kind of basically what the gist of the relocation is. And I will say that sometimes, depending on how far the move is, it is hard to obtain. If the other parent is involved and possibly significantly involved with the custody of the children, it is really hard to then take the child away from that. So it is one of those things that it's definitely good to speak with an attorney before, you have this situation come up. So these are just some kind of important questions, considerations, things to think about either before you file for custody or things to think about that you may want to ask or find out about the other side, about the other parent. So, what is your work schedule? Can you realistically do the periods of custody you're requesting? I've had that before where I was able to get someone, more custody than they could chew, kind of, it was a little bit more than they were able to handle with their work schedule. And then, the next day they call me and they say, hey, I can't do this. Like, I can't find someone to watch the child overnight while I'm working. I don't know what I'm going to do. So it's a little bit of, be careful what you wish for sometimes. So, you really want to have periods of custody where you can actually spend time with your child. So think about, whether you can realistically do the periods of custody that you're requesting or set up the appropriate childcare arrangement. And then what are your childcare arrangements? What will the other parents' childcare arrangements be? Do you have transportation? Any mental health issues that would prevent you from parenting? Are you in treatment for those? Any past or active drug or alcohol use issues? Or does the other parent have had any past or active drug or alcohol issues? Any other health issues that may prevent you from, fully being there? Do you have children other than the child that you're filing for? What is their custodial schedule? A lot of times people like to keep, if you get weekends with your children, you may want to keep your weekends with all your children the same weekend so they can all hang out together and bond, even though their other parents aren't the same. So it's, kind of trying to fit what's a custody schedule that may incorporate, that extended family. Do you have a criminal record? We talked about before, do you have the other party's address? Are you dating anyone? That's usually a big one that comes up a lot. Does that person have a criminal record, especially if they're going to be around your child a lot or live in your household? That is something that, the court does ask about, and they do take that seriously. Is there domestic violence at your home or the other party's home? Has a protection from abuse action been filed? Has Children and Youth Services ever been involved? Any dependency action filed by Children and Youth? What is your housing situation? You've bed space for your children overnight? Who resides with you at least 3 times per week, and do they have a criminal history? And that's just because that criminal form that we talked about you have to fill out before, that applies to both you and then any adult living in your household. So that's why, it is important to, the other parent is entitled to have that information about who is around their child a lot and what their criminal history is. Are you on the lease at your house or apartment? Who takes the child to appointments is another good one. And then we have some other issues, and I do think I did see the question. I'm just going to try to take another second to read it again.
And while Lyndsay's reading, I just want to emphasize too, we can't give specific legal advice, but I think as to, what the process is to transfer a case, maybe from one state to another state or from one county to another county, we might be able to comment on that, and as to any objections or reasons why it wouldn't be transferred. But we may want to go back and talk about jurisdiction first.
Right. So jurisdiction is typically, that's where the case is initiated. So that's where the child has typically resided for the past 6 months. So that's usually where you would want to start filing your case. If your case, if as the question was, you've moved, and it sounds like, in that situation, neither party lives in the case, in the jurisdiction where it's been filed, the correct procedure, in those situations would be to have to file a motion in the case where the custody action is now, asking the court to transfer it to the jurisdiction that you want it transferred to and why. So, the why could just, well, no, we don't live there anymore, we live here. As far as specific objections, if neither party lives in that at all, I can't think of any real concrete reasons that opposing counsel would have that would be able to say that you can't. Typically the court can, even of its own, review those, and maybe say, hey, yeah, we don't have enough here. In situations where there's a question of where the case should be heard, the courts take a look at, where is most of the information about the child going to be found. So, where does the child go to the doctor? Where does the child go to school? Where is the child living? Where is the child's other parent? So that's kind of what information would be helpful to maybe include in a petition when you're moving, is to say, all of those things are in a certain county, and that lets the court know, yeah, if the child's not even here, if the other parent's not here, we shouldn't hear this case anymore.
So Lyndsay, it goes by where the child lives. And if the child lives in, 2 different states, right on the border, let's say, the court would look at where most of the information or most of the contact is.
Mm-hmm. Yep, and there's different things to file to ask the courts to kind of speak with each other as well, so they can kind of hopefully figure it out. But that is the things that they sort of look to, is and additionally convenience of the parties, which one is more convenient. And parties, I believe, can also consent to have jurisdiction somewhere. So if a child is in 2 places equally, they can say, yeah, we understand that, but we prefer our case to be heard in Pennsylvania or something like that. So hopefully, since we can't get too specific with your question, hopefully that answers it a little bit about what kinds of things would need to be done. So it would be a motion in the place or the state, the county where the case is now, asking it to be transferred to where the child is now, and
So-
the reasons why.
Oh, sorry, Lindsay, to interrupt. So if it is a different state, Lindsay, then you would have to talk to or hire an attorney at that state that's licensed to practice in Texas, say it's Texas,
Right.
and they would file the motion in Texas. And then if it's approved, somehow the court transfers the file directly, or
Usually I've only dealt with transfers in county, like different counties in Pennsylvania. So and I don't know if other states have prothonotary offices or how exactly it works, but typically, at least in Pennsylvania, what has happened is, let's say I filed saying this case shouldn't be heard in Dauphin County anymore. Everyone lives in Adams County. The case needs to be moved to Adams County. The court says, yes, we agree. Let's move the case to Adams County. And then they'll direct the prothonotary to send over all the records to Adams County. So that, so that's typically how it would work. When it's different states, I can't comment because I'm not licensed in any other state, but I would assume it works fairly similarly, where the court would direct whatever office collects the civil paperwork to send it to the new court. So.
And I would assume that's often without a hearing. If the other party's not objecting and it's pretty clear cut, you wouldn't even have a hearing, would you?
It's up to the court, but I wouldn't think so.
Yeah. Okay.
Yeah.
And I think we have a follow-up question a little bit, but
Can I ask a question too when you're available?
yeah, we'll go right at.
Sure. So, so in custody, anyone can always file anything at any time. So, yeah, it's kind of hard. Whatever order you may have can always be modified. It can always be changed up to the child is 18. And that is, situations change. So typically, and I think I get the question is, so I think if you would file, if a motion for transfer would be filed and the other parent then files for custody in that jurisdiction at the same time, kind of what would happen. So that would be, the court would have the two motions and they would have to sort of work it out which one they're going to do first. And it's usually kind of based typically on which one is filed first. So they may say, oh, no, the motion to transfer was filed. We need to deal with this before we're going to deal with the other filing. And then if it is transferred, then a court would, that petition could be transferred to the new county or new state along with it, or they would just tell the party you need to go to the new place and file it. So that's usually how that works.
And Terry, did you have a question?
Can I ask?
Yes.
Yes. I wanted to find out if like I know you can't talk about specific situations, but I'll just try to describe my situation just in general terms. Like my son has been with me. He's for the past 11 years and he has not seen his father, but he just talked to him one time in all that time. But he does pay court-ordered child support every month, but just I've not been able to get in touch with him. I try to, I've tried to like every couple of years or so, I just, reach out to him or the last number I had, and just leave a voicemail, but he doesn't return the call or anything, and just say, hi, my son's expressed interest in, meeting you and forming more of a relationship with you. And, but no one calls me back. And so I just wondered, is there any way to, usually it's ironic because usually custody is like fighting over who gets the child. Like, is there a way, like the reverse of it? Like, is there a way to actually get someone else more involved or to try to like, is there some kind of like maybe informal conference where you can like reach out to them some way, Sure.
So unfortunately not. There's not really a way to force someone to kind of be a parent or step up if that's not something that they're interested in doing. and, you know, filing, they could get a court order and say they're going to do, you know, alternating weekends and then just not follow through and do it. And there's not really anything that the court's going to do about that if they're kind of not taking their time. I wouldn't, it already sounds like
No,
that.
I know
that
that.
might be something in your case, but sometimes
is there a
filing
way
for support does prompt the other person to want custody. So that's one way to possibly try to increase someone's involvement, is to ask for support, which may not be as practical in your case. But yeah, unfortunately not. There are, and my very last slide, I do have kind of a resources page, which does have a neighborhood dispute settlement phone number, and they are a local organization that does free mediation. So they may be able to, it's not, you might not get a court order out of it, but you may be able to have them try to contact the father and say, you know, hey, we'd like to have us sit down and try to resolve some of these issues, and that may work, or maybe some way. So on the last slide,
because it's not like there's no animosity between us. I think it's just like, you know, because we had spoken and been on good terms the last time we did speak, you know, but just we have, like, he's not the type to call people back. You know, and so, like, I was just wondering if there's some way to kind of initiate a conversation between us somehow, you know.
Oh yeah, I mean, that's the only thing that I can think of, is to try that neighborhood dispute settlement and try some mediation, and maybe, you know, he'd be willing to kind of sit down and talk about things that way.
Right. I would agree with Lyndsay. I mean, Lyndsay's the expert too,
Okay.
so I'll take her. But yeah, I don't think the court would force anyone, whether there's any other, you know, if the child is receiving any kind of therapy, or if there's other ways through social services or something, you know, or your church, or, you know, some other outside agency, but not the courthouse, is not going to do that kind of work.
No, I would not even want to try to force anything, but I just wanted to see if I could even have a conversation. I would never want to force anything.
Yeah.
You know.
Well, the neighborhood dispute, you know, if you wanted to have a conversation, that may be a way to reach out to them.
Oh, okay. All right. Thank you very much.
Yep, no problem. So just some other issues that may come up are emergency petitions. Typically they are reserved, the court really doesn't like granting them unless the child is in imminent risk of physical harm. That's, you know, unfortunately, it's not just the other parent isn't returning them. You know, that's more often than not, you know, not always, but more often than not something that they'll grant an emergency for. It really has to be imminent risk of physical harm. But if there is something that, you know, really is concerning or going on, that there's always the avenue to try to file an emergency petition. And that's really just to get a court order immediately while you wait to go back to court to try to work out a long-term solution. So they're not, you know, it's a short fix for an issue or a problem. Who can sue? There's other, you know, there are some provisions where grandparents are able to kind of step in and file for custody. There's something that's called in loco parentis, where someone who's basically been stepping in the shoes of a parent is able to file for custody. If they're, you know, it's a step parent who's taking care of the child for a long time, or, you know, maybe an aunt or something who's had the child for a long time, and they've established that, they would be able to file. And then, you know, children and youth can always file in dependency and obtain custody of the child that way. We kind of talked about the different evaluations that the court can grant. Since there weren't any questions about it, I'll just leave, you know, these are here if you want to review them. There we go. So I just have information about protection from abuse or orders on here. So you can, you know, be able to read those and refer back to that. As far as it relates to custody, a protection from abuse action, there are ways to ask for custody if it's an emergency situation, and sometimes the court does grant limited custody in a PFA if the children would be unsafe otherwise. So that's kind of how it relates to the custody. So just kind of in conclusion, custody is very fact specific. Every situation is different. What works for one family doesn't always work for another family. There's different work schedules, different just different dynamics, different everything's different. And that's why sometimes custody is really hard, and that's why it's really hard to be able to give advice specifically to specific situations in this without knowing a whole host of other facts that may be relevant. But the custody process can be intrusive, especially when you involve the courts. So, hopefully knowing the process makes it a little bit easier to decide if that's right for you, if that's something that you do want to try, or, hey, can I just work out an agreement with the other parent and maybe not involve the court, is kind of the first thing we talked about. And we always recommend that if you're able to reach an agreement, especially at the conference level, it's always better for all involved. Once a judge is involved, they make the decision, and then you're kind of stuck with that decision, at least for a little while. Like I said, you can always file to change it, but you're kind of stuck with it at least for a time. And then the process to file is not immediate. It does take some time, so you do need to be patient. If you do decide to file once the paperwork is filed, it will you will be scheduled for that custody conference in about a month. A little month and a week. They're pretty caught up now. They were very far behind with COVID, but it's about a month after you file. If there's not an agreement, then it's about another month and a half until you can be scheduled for a pretrial conference. And if there's no agreement there, then another month and a half until you're scheduled for a trial. So the process does take some time. And then finally, here are some resources that you can refer to, which does include our MidPenn Legal Services 800 toll-free number that you can call to be screened to see if you qualify for our services. In addition, we do in conjunction with the Dauphin County Bar Association, we have monthly custody clinics where we have volunteer attorneys who assist parents in filling out the paperwork to file for custody. And that's a really great resource that we have. Right now, they are also being done virtually, so you don't need to worry about coming in. With COVID, hopefully they'll be in person at some point soon, but right now still virtual. Then there's also the Dauphin County Bar Association lawyer referral number for you, the YWCA Legal Center phone number. And then that neighborhood dispute settlement, which I talked about before, which they do free mediations in the area and can help set that up. And then there's a website, which is the Dauphin County Self-Help website, and they have all of the pro se custody forms on the website, and those are the same forms that we do use in our clinics, but you can also get them online and take a look at them and review them, print them out, and then use those to file for custody if you would like.
The follow-up question in the chat, I tried to answer, but I just want to run it by. If there's no objection to the request for a transfer, it's likely handled without a hearing, at least in Dauphin County. We can't comment on other counties, I know.
Yeah. A lot of times if a motion is filed, at least in Dauphin County, what that process would be is the judge would give the other side some time to respond. They may say, hey, please file, other side, if you want to object to this, you have 10 days or 15 days or however many days to object to this if you would like to. And then if there's no objection or nothing's filed, then the court can rule on the original motion. That's at least how it works here. Again, I'm not sure how every state is a little bit different and how they work, and I can't, unfortunately, don't know about any other states and can't comment on that, but that's typically how the process would work here.
Makes sense. And Lizzie, can you tell us how often do most people in custody situations end up going to a trial before a judge?
No, most of my cases settle at a custody conference. I would say probably 85 to 90% settle at a custody conference. I think, you know, once you kind of get in there and really hear the other side's position, it's a little bit easier to work out an agreement. And our conference officers here in Dauphin County are really great about getting, you know, working people to resolve their issues and reach agreements. You know, every custody conference is a negotiation, so you know you can come in with what you want, and then you want this, the other parent wants this, and you usually meet somewhere here. So that's usually what happens.
Excellent. Well, I think wonderful program. I really appreciate it. And do we have any other questions? Our hour is almost up, but if there's any questions, we'd be happy to address them. And while if you have any questions, speak up. But I just again want to thank Lyndsay and Pam Fleck, who helped on the presentation. What a lovely presentation, and I really appreciate it. I love the whole thing was great, and I hope many people get to see this.